No paper.
Government has no business knowing when I buy a gun or what it is. So,
The government doesn't know anything.
but
They don't know how many guns she's got
they don't. Nobody knows.
or what size, caliber, nothing.
Nothing. We are the Arms Attorneys. Today we are talking about the Supreme Court's refusal to take up the most unjust decision on a Maryland law we've seen in years. Stick around. We're going to talk about what is going on with this Maryland law and maybe what the hope is for Marylanders going forward. But before we begin, show your support for the Second Amendment by hitting the like button. And welcome today, Edwin Walker.
Hello, thank you.
In
It's always
subbing.
good to be here.
Yes, it is. It is a breath of fresh air anytime we get Edwin on the channel. So Edwin is the one who actually brought this case to my attention. The Fourth Circuit opinion we're going to be really raging against actually came down in August of last year, although we didn't talk about it then. But what has just happened is the Supreme Court has said, Maryland gun owners, you're fresh out of luck.
Well, which seems to be a trend. I mean, the Fourth Circuit has been, in the last several years, has been a really horrible repository for the Second Amendment. It's gotten no traction. Basically, the Fourth Circuit is now basically the East Coast Ninth Circuit. So you have the Ninth on the West, the Fourth on the East. Fortunately, here on the Third
They're
Coast,
just giving each other high fives over the country whenever they
Oh,
take away
yes.
someone's rights.
yes, they're country.
Oh, God, bleep that. Go on.
Well, fortunately, here on the Third Coast, we have the Fifth Circuit, which can always
Too.
be counted on to have some very good pro-gun decisions. But that's the thing, is that we were really after Bruin. It was really anticipated that it would be used to kind of pull the Fourth Circuit in line.
Yeah.
But the Fourth Circuit seems completely unimpressed with the existence of Bruin, and Bruin actually plays a part here in that they originally were deciding, use their intermediate scrutiny to judge this case, and then after they did debate it until Bruin and use that. But what is this case about?
Yes. So what we've got here is Maryland's incredibly unconstitutional law, which says you must obtain a permit in order to purchase a handgun. So what are the requirements for this permit? You've got to be 21 years of age. You've got to live in Maryland. Fine. You've got to pass a background check. Fine. I mean, these are federal requirements generally. So okay. I mean, love them or hate them. It's not that out of the norm. But what is out of the norm is that you have to go to a 4-hour class. You have to get your fingerprints done. You have to submit your application, and you have to do so with a $50 fee and then wait. And so, as Edwin mentioned before, this was initially challenged, and I'll give you the style of the case as it has been working its way through the courts here. It is Maryland shall issue Inc. for itself and its members, Atlantic Guns Inc., Deborah K. Miller, Susan Brancato Visas, and Anna Christine Bunch versus Wes Moore as his capacity of the governor of Maryland, and Woodrow W. Jones. So, and we'll link this to link the opinion to the Fourth Circuit.
And this really is a case where Wes is Moore.
Stop. So anyway, yes, we will link the Fourth Circuit's opinion here for you, but we have a case that was originally filed back in 2016, pre-Bruin days. We have a district court that applied intermediate scrutiny because at that point we didn't know how Second Amendment cases were to be analyzed. The Supreme Court hadn't told us yet. And then that case was appealed. But when it was appealed, Bruin was pending. And so the court said, we are going to place this case in abeyance, meaning hit the pause button until Bruin can be decided. And we know then if there is a different standard for us to use to evaluate the Second Amendment. Bruin was decided, and then what happens?
Well, and then they come to the exact same conclusion that they did with their intermediate scrutiny. They determined that...
first that 3-judge panel said that it was unconstitutional.
Sure.
And then, yeah.
Yes. Well, in which what usually happens is that these cases go before a 3-judge panel of the of whatever circuit it's in, and then the losing party, in this case the government in Maryland, because the 3-judge panel found that yes, in fact, the law did violate the Second Amendment.
They applied Bruin faithfully.
But since it's the Fourth Circuit and since it's a Maryland law, the Fourth Circuit agreed to hear the case en banc,
En banc.
en banc, and which means that the entire court heard it. And once the entire court heard it, I believe it said arguments were back in March. They issued the opinion in August that said what?
It said, not only is this law constitutional, in addition, this isn't even a Bruin issue because Bruin says that shall issue schemes are essentially per se constitutional, which is not really what Bruin says. But the court says this isn't. Because of the Bruin decision, we know on its face that a shall issue scheme does not infringe upon the Second Amendment, and thus we don't even get to the government doesn't have to justify the regulation based on historical analog. We don't get there. We know from Bruin that this is no infringement at all. But that's not true because Bruin was about carrying firearms, and this is about the simple possession.
Correct. So one of the things that I want people to remember is that whenever you just throw out the words "shall issue," it's a shall issue licensing scheme, so it's okay. There's no discretion, which was the issue in Bruin.
No proper
It's a
cause. No,
but
yeah.
keep in mind that this is not for a license to carry, so it's not like say Texas, where Texas has a shall issue scheme, but it's only for the purposes of carrying. It by no means infringes on a person's ability to go in and go to the gun shop, purchase a firearm, have a firearm exchange with their neighbor or their cousin or their friend or what have you. The Maryland law does not apply to carrying. It applies to the actual acquisition of the handgun. And so they're saying that you have to meet all these requirements, have a license before you can even acquire a handgun, much less consider carrying it around.
Right. And think about how many people are deterred entirely from the purchase of a firearm, not because they can't satisfy the requirements, but because it is simply too onerous to have to do this when you buy a gun. Or maybe it's not too onerous. Maybe you can get the time off work or away from your family. Maybe you've got that extra $50. Maybe that you love paperwork.
And
love it. You can do the application, but maybe you just don't want to. You want the government to know.
And one of the things that's really very onerous about this that may not jump out at you to begin with is the fact that this license has to be renewed in 10 years.
Yes.
And so now
it's not permanent.
No, and so now they've taken a ministerial duty, basically the renewal of the license, which doesn't have anything to do with your ability to legally, to legally acquire the firearm, doesn't have anything to do with you being a dangerous person, as we saw in Rahimi. It's just a purely ministerial duty that many people will either forget or fail to do for some reason. And then the day after your license expires after 10 years, guess what happens? You become illegal to possess all the handguns that you acquired during that previous 10-year period.
So, I mean, it is. You could have knocked me over with a feather when the Supreme Court declined cert on this case. And this just happened. You're probably watching this on Wednesday, January 15th. This happened Monday. This happened a couple days ago because it is such a blatant workaround. In fact, there's a great line from the dissent because of these 16 judges, 16 who heard this case, alone 2 actually had the stones to faithfully apply Bruin, dissent, and say, look, you did the Second Amendment dirty. But here, this is one line I really, really like from the dissent. He says, I cannot assent to this transparent workaround of governing doctrine. And that's really what it is. It is, we are not going to apply Bruin because we know if we did, we'd lose. So we're going to weasel our way out of it. And I just cannot believe the Supreme Court did not take it up.
I know. The Fourth Circuit is a literal dumpster fire when it comes to the Second Amendment. It really is. With upholding the Maryland assault weapons ban, with any Second Amendment decision that's come down before it. And so, maybe things will change depending on how many vacancies occur in the next 4 years. But for now, I would not want to be in a state that is so adamant about their gun restrictions that happens to exist in the Fourth Circuit.
No. And that dumpster fire will continue to burn until the Supreme Court checks them, because that's the only way to stop it, really. Because I don't see Maryland flipping anytime soon. I don't see good politicians getting elected. I don't see the laws changing significantly. So the way you do it is to have the court system do its job and be the checks and balances on these unconstitutional anti-gun laws. We'll see. So there is one bit of hope here, and I wonder, I don't know, does the Supreme Court have too many Second Amendment matters to take up already, and this is just not their priority? I'm not certain, but there is another case that has challenged this particular law that the Supreme Court just did not. They've been. My understanding is PDR has been requested. So the parties have requested the Supreme Court to take it up, and they just didn't rule on it Monday at all. So maybe they'll take that one up.
Possibly, but there's always room for another Second Amendment case on the Supreme Court's docket.
Well, you would hope, and it's so easy. It's so easy after Bruin. But anyway, so what advice do you have to the people of Maryland right now, Edwin Walker? Revolution? I mean, truly, this is such an injustice.
It is an injustice. And Maryland, once a very proud, patriotic state, of course, the site of Fort McKinley, home of the Star Spangled Banner. You would think that they would embrace their liberty more. And really, the thing about it is that I think that their best route is to try to flip the legislature.
Good luck.
I know there's just too many Washington, D.C. suburbs in Maryland, and I know that's going to be tough, but you folks in Western Maryland, try to get out there because, ultimately, yes, the courts are there to protect our individual liberty, but we wouldn't have to worry about protecting our individual liberty if we would elect politicians who wouldn't threaten that liberty to begin with.
No, that is very true. Well, people of Maryland, you are in our thoughts here. Maybe the Supreme Court will take up a similar law and save you. Maybe you can move to a cash only, no papers state, like in our great state of Texas here.
Cash only, no paper.
Government has no business knowing when I buy a gun or what it is. So,
the government doesn't know anything.
But
they don't know how many guns she's got.
They don't. Nobody knows.
Or what size, caliber. Nothing.
But we hope you've enjoyed this discussion. If you did, consider subscribing, hitting the like button, and please help us fight that anti-2A algorithm by sharing this video. And let us know in the comments below, why do you think the Supreme Court turned down this case? Until next time, we're the Arms Attorneys.